To the First District Court of Appeals. So as I understand it, we're going to start off with arguments in the consolidation of two cases. Is that correct?
We were going to discuss McCain and Sean.
And Sean. Okay, so the first argument will be case number C190616, which is Sean versus Durrani et al., and C190700, which is McCain versus Durrani et al. Just to make it clear, if each counsel can please identify themselves and their readiness to proceed.
Yeah. Good morning, judges. Robert A. Winter Jr. on behalf of Messrs. Chun and McCain. We are ready to proceed.
Good morning.
Morning, Aaron Herzig on behalf of appellees Durrani and Cast, ready to proceed.
Thank you. Attorney Winter, would you like to reserve some time?
Sure. 5 minutes. But before we proceed, I just wanted to say that these two cases are basically indistinguishable from the case of Douglas Hayes versus Durrani that Judge Myers wrote an opinion on very recently. And I can't say in good faith how it can be any different than what Judge Myers ruled.
I do understand. I think you have that. You've had that pending with the Supreme Court. Is that right? You're waiting to hear from them.
Well, I filed. I think Mr. Herzig has yet to respond. His time's not up.
Okay, thank you.
So, I mean, just to very briefly summarize, Durrani fled Ohio suddenly in November of 2013. He didn't attend trial below. We had a pretrial conference. The trial judge ruled that there will be no flight instruction. We requested a flight instruction because it was probative of liability or responsibility on the part of Dr. Durrani. That was rejected. We had relied on, among other things, two Indiana Court of Appeals cases that we felt were highly analogous, if not directly on point. And nevertheless, it was kept out on that basis. The other reason that was discussed by Judge Myers that we had argued was that we would need the flight of Dr. Durrani to cross-examine his trial medical experts. The only way that Dr. Durrani appears in the case, even close as a witness, is his medical records, which come in under the medical records exception. We contended vigorously that they had materially misleading, if not false, statements about his care and treatment of these folks. We felt that the fact of Durrani flight suddenly November 13 from Ohio would be useful in cross-examining these defense expert witnesses. That's the summary. It was rejected by Judge Myers, and it's at the Supreme Court, and I guess this one will be too. Excuse me. And that's what I have.
Thank you. Thank you, Attorney Winters. Attorney Herzig.
Good morning, Your Honors. May it please the court. No disagreement. We think that Hayes, as decided by this court, governs this case. As appellants point out, the facts are analogous. The instructions and the pretrial order are basically the same. We think it's the correct outcome. If you let in this evidence, these cases become about the character of the person, not about the facts of whether there was or was not medical malpractice in any particular case. So we think Judges Zayas, Krauss, and Myers all got it right in Hayes, and we would ask this court to affirm on that same basis.
All right, thank you. Well, ultimately, what was before us was whether it was an abuse of discretion. Is that correct?
That's right. Abuse of discretion standard applies. We don't believe that the unconscionability standard is there. Can't go that far. But the other two we believe were there. And thus we ask, it's not about Durrani's character, it's about what it deals with his belief of liability responsibility. It is abuse of discretion standard. Yes, Your Honors.
All right, if there's nothing further and no questions from the panel, then we will take the matter in the submission and issue a timely decision. And
Your Honors.
Thank you,
thank
judges.
you. So we have now Attorney Mitchell, who will be joining us.
Good morning, Your Honor.
Okay.
Morning.
Good morning. And so now we're going to proceed with the case number 190744 and 745, which is Baumgartner versus Durrani et al. Attorney Herzig and Attorney Mitchell, will you be splitting time?
Your Honor, to the extent necessary, yes, and Ms. Mitchell will go first.
All righty. So is there an allotted time that you guys have agreed to?
I don't know that there's going to be a lot to argue. I think we've spoken with Mr. Winter about that as well, given the recent decisions. So I don't think we're going to have an issue timing wise.
Okay, understood. All right. Attorney Winter, would you like to reserve time?
Oh, 5 minutes is fine, Your Honor, but I don't think we need to get that far.
Thank you.
First, Robert A. Winter Jr. on behalf of the Baumgartners and who's the other one? Brown. Yeah, Michael Brown. Brophy, excuse me. And we're ready to proceed.
Thank you. If you can go ahead, whenever you're ready, Attorney Winter.
Sure. Judges, this is another fraud and medical malpractice case against Durrani and Cast. We have all of the defendants here, both the doctor, the practice group, and the hospital, which is rather unique. The claims that we assert are negligent credentialing against Christ Hospital only. We assert the judicially engrafted fraud exception, the argument that fraud is not a medical claim, and also can't think of it now. But the point is that this court has stated several times its belief on our arguments about a judicially created fraud exception to the statute of repose, and also the concept that under these facts, fraud is not an independent claim. And judges, I don't have anything other than to offer you in the way of facts to dissuade you from the facts presented being independent non-medical claims. So I think that deals with all three appellees' objections to my arguments. The only thing I have for you is negligent credentialing against Christ Hospital. The court has been indicated that negligent credentialing is a medical claim under 230511 3, and thus and thus is governed by the statute of repose. And where that's pretty solid law in the first district, I would just ask again that you take a look at this in the forthcoming motion or application to certify a conflict. The last time the court stated unequivocally that negligent credentialing is a medical claim is in the Couch case, stated very, very clearly and unequivocally that point. I would ask that you though take a look at the 11th district and the 6th district's cases where they state unequivocally that it's not a medical claim, and deriving their conclusions that the 2-year statute of limitations governs negligent credentialing claims and not the 1 year or 4-year statute of repose. To get to that conclusion, they state that negligent credentialing is not a medical claim. It's an independent claim against the hospital for its negligent credentialing or retention of an incompetent doctor. The incompetent issue is dealt with at 2305.251, where it talks about my burden at trial of what I have to show that the hospital knew or should have known about an incompetent doctor in making that credentialing decision. So when the forthcoming motion comes, please take a look at the Erickson and Malcolm cases. By the way, I think that language was affirmed recently in the Evans case at the Ohio Supreme Court. I just ask you to take a look at it. And with that, I've concluded my discussion.
Good
Thank
morning,
you.
Attorney Mitchell.
Yes, as we previously argued to this court, and as this court recently held in its Jansen decision, in that consolidated set of cases on April 28th, 2021, we would rest on the authority of that decision and say that it is applicable to all of the arguments outlined in the Baumgartner and Brophy cases that were combined into this appeal here, as well as remaining cases that I believe are also on deck for today. But Mr. Baumgartner's procedure was in July of 2009. Mr. Brophy's procedures were in 2008. All of the same issues pertain with respect to the statute of repose, as governed by this court's recent decisions in Jansen and Couch on March 12th, 2021, as well as Jonas on July 22nd, 2020, and all of the prior decisions there too. So we would just rest on this court's rulings in those cases and submit that they are applicable to these cases as well. And the trial court's decision should be affirmed. Thank you.
Thank you. Attorney Herzig?
Thank you, Your Honors. Aaron Herzig on behalf of appellees Durrani and Cast. The only thing I would add is, to the extent the issue of judicially created exceptions to the statute of repose hasn't been specifically taken up by the Supreme Court, I think its decision in Wilson forecloses and affirms what this court has repeatedly said, which is that there are no such exceptions. In paragraph 38 of Wilson, the court says that there are no exceptions to the statute of repose except those written into the statute of repose at section C and D, which would of course preclude judicially created exceptions. So this court has gotten that decision right time and again, and we would ask it to affirm on that basis.
Thank you. Attorney Whitson?
Just the last point, the legislature doesn't have the power to set aside, attenuate, or dissipate this court's inherent judicial power to attenuate fraud. And we've said that time and time again, and I agree with Mr. Herzig that it has not been accepted again. Although I will say that the trend at the Supreme Court on the point is getting better for the appellants. We did receive one vote the last time the matter was discussed, and the trend is in the right direction. We received 3 votes on the last time negligent credentialing was, maybe it was 2 times ago, but the trend's in the right direction. We'll see what happens this time. Thank you.
Thank you, everyone, for your arguments this morning. We will take the matter under submission and issue a timely decision, and I wish everyone a wonderful afternoon and a great week.
Thank you, Your Honors.
Thank you.
Thank you.
Judge Tice, just sign off.
Okay.
I just wasn't sure if we had covered the other cases that were on deck officially.
Right.
I thought we did have a couple other cases.
I thought not, but so
We
need
good?
to- well, I think we need to go through the drill of the inventory and then
Okay.
state what we state.
All right. Just give us a minute.
Sure, absolutely.
I apologize.
So many buttons to push.
All right, so my understanding is the remainder of the cases will be argued by Attorney Winter and Attorney Mitchell. Is that correct?
That's right.
Okay,
Yes.
and so Attorney Herzig, you're welcome to.
Thank
take-
you, Your Honors.
Thank you. All righty. And for clarity, we have case number 200185, which is Masters v. Durrani et al.
Right.
Okay, C190726, 2728, which is Deaton versus Durrani et al.
Judge, this one thing that this case originally started off with as a under a different name,
Okay.
Alyssa Flatt, and she was dismissed as the named plaintiff in this consolidated action, and that's how we got to Ollie Deaton being the lead plaintiff.
Okay, thank you. The next one is C19067172737475. The lead on that is Smallwood versus Durrani et al.
That's right.
Okay, and the last one that I have is 729 C1907293040 Worley versus Durrani et al. So
That's
all
right.
of these will be argued, consolidated this morning. And Attorney Winter, would you like to reserve time?
5 minutes.
All right. Whenever you're
Your
ready.
Honor, Your Honor, Robert A. Winter Jr. on behalf of the appellants that have been listed and identified by Judge Zayas. I have nothing further to present subsequent to the court's discussion of Evans in the Couch case, and then the 2305.251 matters in Jansen, which we'll be filing more documents on that this afternoon. So if I may, could I incorporate by reference my discussion in these cases that was made a few moments ago in the Baumgardner consolidated case? And if that is acceptable to court, I have nothing further to offer.
It is, thank you. Attorney Mitchell.
Likewise, I would do the same and incorporate all of the arguments made on behalf of the Christ Hospital with respect to these, I believe, 12 additional plaintiffs' cases. And I would submit that this court's recent decisions in Couch, Jansen, and Jonas should likewise pertain to these cases, and the decisions of the trial court should be affirmed. Thank you.
Thank you. Anything
Just a
further, Attorney Winter?
That's a conclusion. To conclude, the appellants pray that the various entries of the trial court be reversed and remanded for further proceedings.
All
Thank
right,
you, judges, for your time.
Thank you both for your arguments, and we will take all of these cases under submission, issue a timely decision. And I wish everyone a wonderful afternoon.
Same to
Thank
you.
you.
Thank you.